Okay, well, good morning, everybody. Welcome to outline the DLA Piper Planning Law update. We had a break for the Easter school holidays last month, so we've got a bumper month to catch up with today. My name is Trevor Ivory. I'm the UK Head of Planning for DLA Piper. I'm joined today by two of my colleagues from the planning team, Howard Bassford, a partner in the team and head of our infrastructure planning practice, and an associate from the team, Tobias Paul. So welcome to them and thank you for joining me. The usual format, we will try to keep to time, and we'll strictly be finished by 9:30, and we're aiming for about 45 minutes of discussion on some of the key, or what we think are the key and most interesting developments in planning law since our last session, and then with about 15 minutes at the end for your questions. There is a Q&A function if you have questions, so please do, as we go along, put your questions into the Q&A box, and I will try to make sure we deal with as many of them as we can at the end of the session. We are also recording the session as usual, and so if you enjoy it that much, you'll have the opportunity to watch it again. We'll circulate the link shortly after the session ends. But without any further ado, let's make a start. So if we can go to the first slide, please. And I just wanted to flag up a few legislative changes that have happened in the last month or so. Firstly, yet more changes to the English General Permitted Development Order. This time, the changes take effect, or took effect, from the 21st of April. There are a number of changes in the amending regulations, but I think that the key one, which has been quite well publicised, so I don't plan to dwell on it, is the introduction of a PD right to change from the new use class E to C3 dwelling houses. There are some notable limitations on that right, and there is also a prior approval process, but nonetheless potentially quite a significant and wide-ranging ability to repurpose various different types of use of building into C3 dwellings. The second change of PD rights, this one is a coronavirus related one. I would suggest it's the most important bit of legislation that we've seen for a long time. It has created a temporary permitted development right, allowing pubs, restaurants and other types of businesses to provide mobile structures within the curtilage of the business premises in order to make sure that we can all get back eating and drinking as quickly as possible. And I'm sure many of you have already taken advantage of some of those structures that have been in place. That PD right came in on the 16th of April. Any buildings, any structures that are brought onto premises as a result of that PD right are allowed to remain in place until the 1st of January 2022, by which point they will need to have been removed. The last three bullets on the screen, various different directions that were issued last month by the Secretary of State. They all relate broadly to the treatment of statues, monuments and memorials. The first, the demolition direction, effectively excludes a number of statues, monuments and memorials from the PD right, allowing demolition without the need for an express planning permission, so requiring planning permission to be sought if those types of structure are proposed to be removed. And then the last two directions broadly relate to what are described in both sets of directions as commemorative objects. If a planning authority is minded to approve a proposal for a removal of a commemorative object, then there is a requirement to notify the Secretary of State and give him an opportunity to be consulted. And in the case of listed or other heritage type objects, there's also requirements to consult with Historic England under the last bullet. So that's broadly what the last three directions on the screen deal with. On to the next slide, probably more important this month than the legislative changes that have been made. If we can go to the next slide, please, are the legislative changes that we're told are to be made. With yesterday's Queen's speech, we saw a number of planning-related bills proposed for introduction in this new session of Parliament. The first will be familiar to us all, the Environment Bill. I think this is the third time rather, that it's been introduced into Parliament. It was originally intended to be in place to avoid a gap when we left the EU. Clearly that hasn't happened, but the will would appear to still be there in government to make sure that we have an Environment Act in due course. So the Environment Bill is back with us. And in fact, if you're following that bill, then very hot off the press at about 11:30 last night, the latest version of that bill was published on the Parliament website. So the next version is there now for your perusal if you wish. According to all the media reports since the Queen's speech, by far and away the most controversial bill is a planning bill. The planning bill, I'm not planning to say a huge amount on at this time, largely because we don't have a bill, and it feels to me as if there's an outline special edition coming up. But looking at the notes supporting the Queen's speech that the government published, it would appear that they are proposing to take forward most of the proposals that were set out in the Planning for the Future white paper at the beginning of last year. So potentially some really quite fundamental reforms of the planning system coming our way, or at the very least some arguments in Parliament about whether we should carry out fundamental reform of the planning system. Two others worthy of note, following the passing of the High Speed 2 Phase 2A legislation earlier this year, the next tranche of the route is proposed to be brought forward in this session. That being the HS2 route carrying on from Crewe to Manchester, so a new HS2 bill coming through there. And finally, for planning, the other one with potential significance is the Judicial Review Bill. That is not planning specific, it's looking at JR in its wider context and proposing some changes to the system. And they may we'll monitor that and report back in due course, but that may have an impact on planning for obvious reasons. Alongside the bills that were announced in the Queen's speech, there were a number of various consultation papers and other publications that came out. I thought that the one that caught my eye in a planning context was the National Infrastructure Plan. Howard, with your infrastructure hat on, I don't know whether you have had a chance to look at it, to put you on the spot there, but do you have any initial thoughts?
Well, the thing about the National Infrastructure Plan is, of course, in the way of these things, it is not a plan per se. So the government will be being very wary to avoid it being characterised as such, so that it's subject to strategic environmental assessment. But really, it's one of those things at present, as far as we can tell, that is very much retreading and re-announcing a lot of initiatives that began last autumn with the National Infrastructure Strategy. And so there are a number of things that that can be seen to be being brought forward, and it's sort of a progress check against a number of those. So you see the government recording again its investment of 100 billion in capital expenditure in FY 2021 to 2022, and that's a 30% increase in the preceding year. You see it reminding us of the UK Investment Bank, which is going to be based in Leeds, and its equity for lending of 12 billion, which the government anticipates will bring forwards 40 billion in terms of investment in infrastructure. So it's very much layering in the resources to bring things forward. And then you see the government referring to Project Speed. That's very much an internal civil service and politician reference until now. Now, Project Speed has been number 10 and formerly Dominic Cummings' work in order to speed up the delivery of infrastructure. And there is something running stick of rock-like through a lot of this relating to planning in the proposed planning bill, but also in this, about sort of faster, greener, better delivery of infrastructure projects. There is, of course, a tension in that there will be a need to maintain protections and enhance them under, say, the Environment Bill, but at the same time the government say that it's looking at the environmental regs in order to make sure that that projects can come forward more swiftly. A couple of things to watch there. First is whether that is a source of friction with the European neighbours, in that it could cause divergence in terms of the protection afforded to the environment, EIA and so forth. The second thing is that in making things faster, greener, better, what the government's often looking at are the statutory procedures, and a solution to that, and the optics of it, is simply to move the controversial, time-consuming elements into informal statutory consultation, such as under the Planning Act 2008, and leave the statutory processes much shorter and swifter, so it looks like things are going more quickly. So the real interesting point there is going to be whether whole inception to delivery time gets quicker, or whether just the statutory procedures as well.
Faster, greener, better. That's the slogan of the day. I like that. Thank you, Howard. So if we can go on to the next slide, just in terms of what we're going to talk about for the rest of today's session, we're looking at a few cases. Firstly, a case on Community Infrastructure Levy and particularly liability notices. Then a case on the habitats regulations assessments, which was a case in the Court of Appeal, and then we're going to end. It wouldn't be an outline planning session if we didn't mention EIA, so we're going to end with a run of cases that have happened recently on EIA screening in particular. Tobias, I think you've chosen to talk about the Trent case today. You wanted to talk about it, so do you want to start sort of giving us the background of the case?
Yes, thank you, Trevor. So the Trent case is Mrs. Justice Lang in the High Court once again explaining just how simple CIL can be. The short summary is that it's a case where everyone did everything wrong. The slightly longer summary of what the case is about is slightly more interesting. At its most basic level, Mrs. Trent had applied for planning permission to knock down the house next door to hers and to replace it with a new, larger house for her and her family to live in, so that she could look after her sick mother. It was a self-build project, so she filled out the form for a self-build exemption. However, she didn't fill out an assumption of liability form. Planning permission was eventually granted, and she started work without serving a commencement notice. So everything going fine so far. What then happened is that the council found out that she had started the work and indeed completed the work, and they served a liability notice in 2019. Without any self-build exemption, because she hadn't met the criteria for that exemption. And the amount of CIL that she was asked to pay was in the region of about £16,000, which it will come as a nice surprise for her.
So did it come as a nice surprise? What did she do when the demand notice hit?
Well, see, this is the weird thing, because if you actually go through the judgment, Mrs. Justice Lang actually spends quite some time setting out what actually happened when and who sent what to whom. Because the first question was, when was the actual CIL liability notice served? Because it's not clear if there were, first of all, it's not clear if there was one liability notice or two. And so what the LPA said was that, oh yes, we granted you planning permission in February 2017, and we issued a liability notice in February 2017, and look, there's even a draft of it on our computer system. So that's what we sent you 4 years ago. The council, however, after they found that she had started the work without serving a commencement notice, decided to just in 2019 serve a new enforcement notice, which she did receive, but they posted it to her business address in London rather than her actual address or the property address in Hertfordshire. And And then after they'd sent that second liability notice in 2019, they very quickly followed that up with a demand notice saying, pay everything immediately or we'll take enforcement action against you. When she got the demand notice, which also included surcharges because she hadn't assumed liability to pay and she hadn't served a commencement notice, she then appealed that under the CIL regulations to the Planning Inspectorate. What then happened is that the inspector quashed the demand notice. The first reason that the inspector quashed the demand notice is because there'd been no commencement notice, the council had to establish a deemed commencement date, which they had put in as the 1st of June 2019, which was when they'd just done their site visit to see that the work was completed. However, Mrs. Trent had already told them, the council, that the work had been completed in January of 2019. So the inspector quashed the demand notice because the commencement date specified in it by the council was incorrect. However, the inspector also came to the conclusion that the council had not in fact sent a liability notice in 2017, partly because the council had no evidence that they'd sent anything, no email log, no postage receipt or postal log, and also because the document that was on the council's computer system wasn't complete. So even if they had sent it, it would have been defective. And then what is interesting and what gave rise to this court case is that the inspector then went on to look at the 2019 liability notice and said, well, you served this 2.5 years after you granted planning permission. That's not as soon as practicable. Therefore, it's not a valid liability notice. Now, the problem for Mrs. Trent is that under a CIL regulations appeal, the inspector does not have jurisdiction to quash the underlying liability notice. However, as far as Mrs. Trent was concerned, the inspector had looked at it and said no valid liability notice, so she didn't have to pay. And then as far as she was concerned, that was going to be the end of it.
So Mrs. Trent is quite happy at this point, presumably. So how does she then end up bringing judicial review proceedings?
Well, you would have thought the council would perhaps think better of it, but pretty much immediately after the inspector had issued his appeal decision on the CIL regulations appeal, they issued a new demand notice saying pay £16,500 or we will take enforcement action against you. So Mrs. Trent was understandably somewhat aggrieved at this, but in order to avoid the risk of getting slapped with an enforcement notice, she paid the money on sufferance. However, because of the way the CIL regulations are structured, the only legal recourse she had to try to get out of this new demand notice was to bring judicial review proceedings. So she was forced to start a High Court claim for judicial review seeking to quash the demand notice. And so that's what the actual High Court case was about. Mrs. Trent was fortunate in that I understand that she is actually a commercial property solicitor. So she was able to, in effect, run that case herself. But for a lot of other people, then it's not something that they would necessarily readily have been able to do. So it just so happened for the council that they sort of served that demand notice on the wrong person.
And so what did the court decide?
Ultimately, Mrs. Justice Lang, as I said, went through at quite some length the history of what had happened and who had sent what to whom. She agreed with the inspector that the council had not, in fact, sent a liability notice in 2017, just on the evidence. And she then concluded that when they sent a liability notice in 2019, that wasn't as soon as practicable because it was 2 years and 6 months, less 5 days, since the planning permission had been granted and the charge had come into being. And so Mrs. Justice Lang's view is that that is clearly not as soon as practicable, with a delay of 2.5 years, and therefore it cannot constitute a liability notice within the meaning of the regulations. And if there's no valid liability notice, there's nothing for you to base a valid demand notice on. So she quashed everything.
An unexpected outcome.
As I said, it's a salutary reminder that there's been a litany of cases over the past few years where developers and landowners have been caught out because, for example, there was a case where the developer emailed the council to say we're starting work on this day, and that was held not to be a valid commencement notice, and the developer had to pay all of the CIL, which in that case was over £1 million up front, and the courts forced that developer to do it. So this is it's interesting to sort of see the turn of the screw with councils being told, no, these are quite technical regulations, you need to do it properly as well. And it's interesting because it's implicit in the court's reasoning that if a liability notice isn't served in time, whatever that might mean, there is no mechanism in the CIL regulations to cure that defect. So if you don't serve the liability notice in time in the first place, there's no mechanism to correct that, and therefore you can never actually serve a valid liability notice, and then the CIL is never actually enforceable against anyone.
Quite a significant impact. Thank you, Tobias. So I think now, Howard, you're going to talk to us about the habitats regulations and Legoland, I believe.
Yes, that's right. This is a case which relates to two real themes. The first is veteran trees, reasons in planning decisions, policy considerations, classic planning, fodder, or grist to the mill of the court. And the second one is about appropriate assessment under the habitats regulations and the way that section 31(2)A of the Senior Courts Act works. And that's the provision which says that if the outcome would have been the same anyway, the court doesn't have to use a procedural defect in order to overturn the decision. And the way that that works alongside European legislation remains something important. So those are the themes that come out of this case. And DLA Piper was acting for the Legoland parties in relation to the case. So we had a ringside seat on this.
So why did it actually end up in court at all? Because normally that sort of shows things have gone quite badly wrong.
Well, this is actually something where, on closer inspection, it's not like Mrs. Trent. Things had actually gone fairly well, and we'll come to that later. But it was an application by Legoland Windsor for a holiday village, and that is a site which is very successful, and the development is potentially economically important, and as things open up, this remains very important for the local and UK economy, these types of visitor attraction. And it's in a bosky location. If you've ever been to Legoland, then you'll appreciate that it's in an area with a lot of woods, and that's part of its attraction too, and that is part of the green belt. And at the application, there was a debate between Legoland and its advisors, and on the one side, and on the other side with the council, about certain trees and whether they were veteran trees, which are of course protected under paragraph 175 of the NPPF. And the question then followed about whether those trees would be harmed. At the same time, the project being in the green belt has to make out the case for very special circumstances. The matter went to a planning panel in the committee role, and not much was said at that point about trees, because largely the concerns had been resolved as between officers and Legoland, and there were a series of reports and representations from Legoland Windsor all about how trees were protected and the relevant qualities of the trees. The debate before the committee was about the classic greenbelt tests, and having satisfied themselves, contrary to an officer's recommendation on the greenbelt tests, the committee decided that it was going to authorise the grant of planning permission subject to resolving mitigation matters, section 106 and the usual sorts of things. That took a number of months, almost a year to resolve. And following that, there was a grant of planning permission with reasons, conditions, and a section 106 agreement. And in 2019, the local head of the CPRE challenged that grant of planning permission, including on the ground that appropriate assessment should have been undertaken and was not.
And so you mentioned that this was a Court of Appeal decision, though. So what was it that the High Court had said when it went to them in the first instance?
Well, the key player in the High Court was, again, Mrs. Justice Lang, who is one of the most prolific planning judges, and we see her time and time again, and her judgments often being big ones that we deal with. And it is quite an entertaining read, this judgment, because the Court of Appeal is plainly somewhat irritated that it's having to deal with this. And it's a 24-page judgment, which by judgment standards is relatively short. And they do point out that there were more matters before the Court of Appeal than there were before the High Court. So on the veteran treason policy point, the Court of Appeal found that the judge was right at first instance, and that the suggestion had been made that a person ought not to have to read multiple documents to undertake a paper chase in order to understand the permission, the reasoning, and so forth. And the court found that simply having to read the permission on its face, the conditions, the reasons, and the Section 106 was not unduly onerous and was entirely appropriate for a person to understand the permission granted. And that was ground 2. There are 3 other grounds on this particular part of the judgment. The court found that the question of harm or otherwise to trees had not been mixed up with the question of harm to the greenbelt, and that was one of the points that Mr. Hudson brought. And the formulation about other harm was something which the panel had taken into account in resolving to grant planning permission, but in doing so, it had not confused the concept of harm in terms of the greenbelt with harm to the veteran trees. And the Court of Appeal determined that the panel had found accurately and that Mrs. Justice Lang had made an accurate finding. And then finally, in relation to the NPPF test, the Section 175 C test, which is about protecting veteran trees should there be harm to them, the court found that there were 2 particular points. The first is whether the trees were veteran trees at all, which was considered, and there were findings in relation to that. And second, whether there was harm predicted to those trees, and it found that entirely properly the panel and then the court at first instance had resolved the question and found that there was no harm predicted to the trees as a result of the measures encapsulated in the planning permission, all of the documents to which it referred, and the Section 106 agreement. And so those sort of classic policy grounds and findings of fact were left intact by the Court of Appeal, and it seems to me that it's a fairly confident judgment on all of those aspects. The next point is slightly more recherche, though.
Yes, so I was sensing a but there. So what did the Court of Appeal say on the second line of attack, which was the habitat's appropriate assessment?
Well, in relation to the appropriate assessment, the allegation was that no appropriate assessment had taken place, and that as a result, the decision was incorrect. But the court, and this is the good news again, although the point is slightly finer, the court found that there was no particular problem here because there'd been ample assessment. I referred earlier to the to and fro between Legoland and the council, and also Natural England. And Natural England was satisfied. That's the official statutory advisor on effects to the natural environment. They were satisfied as to the absence of adverse effects on the relevant trees. That consultation had taken place with the public, and the officers themselves had concluded eventually that mitigation could be secured. The court then found at first instance that, and the Court of Appeal agreed, that the approach was consistent with the Habitats Directive, and noted that the panel had simply followed the officers' advice. It wasn't a situation where you could not see how they had departed from officers' advice. And the point about consistency, I think, is important because the Court of Appeal could have formulated its decision slightly differently. And this is one of the things about appropriate assessment and environmental impact assessment. It's not the document, the environmental statement or a habitats regulation assessment statement, that is the assessment. The assessment is performed by the decision maker at the point of decision. And so I think it would have been open to the Court of Appeal to have found that appropriate assessment had taken place, even if not badged as such. And so I think that the finding about the habitats regulation assessment, the appropriate assessment, the consistency was important. This then brings you on to the Senior Courts Act point, because the appellant, Mr. Hudson, argued that the test under the case of Ultrib, which is a European case, was that there had to be certainty that the outcome would have been the same had the correct procedure been followed. And the court, as opposed to the Senior Courts Act test, which is that which is about a high degree of likelihood that the outcome would have been the same. And the court looked at a series of cases, including Champion and the more recent Canterbury City Council case, and the court found that the point about consistency, about certainty, was one that you had to look at in the circumstances of the case. You have to look at the seriousness of the breach in terms of the procedural irregularity. You have to look at whether there was truly a deprivation of the ability to comment, and then whether there was prejudice as a result of those. And in fact, the court found that none of those things had happened. As I mentioned earlier, there was an ability to comment during consultation, that there was consistency with the Habitats Directive approach, and as a result, there wasn't prejudice. And quoting Mr. Justice Dove in the Canterbury case, the court just reminded everyone that it's not for judges to substitute their view, and that's about certainty, when you have to look again at whether the outcome would have been the same. That isn't an invitation to the court to step into the shoes of the decision maker. They don't have the case file. They don't substitute themselves for the officer or the panel. And as Mr. Justice Dove puts it, they must not go into the forbidden territory of standing in the shoes of the decision maker there. And again, that ground failed. So all in all, a fairly gratifying result in terms of the decision there. The matter is still subject to an appeal deadline in a couple of weeks, but we wait to see whether the complainant takes it any further. So that was what I was intending to say about the Hudson versus Windsor case. Trevor, you have a number of cases that you have been looking at, and I wonder if, first of all, I think the first one you're going to mention is Swire. So tell us a little about that.
There are some similarities, actually, Howard, with the case, the Legoland case you've just been talking about, in that it's the court sort of not taking too overly legalistic an approach to the interpretation of in this case the EIA regulations. And so in the Swire case, the case concerned a challenge to Ashford Borough Council's decision to grant planning permission for a winery and a visitor centre. There's an alcohol theme to everything I'm saying today. A winery and visitor centre on agricultural land in Kent, and critically, it was the site was within the Kent Downs AONB. Before the application had been submitted, a request had been made to the council for a screening opinion, and the council's screening officer had issued a negative screening opinion, so confirming that the development, whilst it came within Schedule 2, was unlikely to have significant environmental effects and therefore didn't constitute EIA development and didn't therefore need to be subject to EIA. So all good until that point. The application goes in and is accompanied by a detailed landscape and visual impact assessment, as you'd expect in the AONB, and the AONB unit, the body responsible for sort of protecting the integrity of the AONB in Kent and responding to planning applications, they were unimpressed. I think it's probably fair to say, and over a number of representations, they submitted some significant objections to the application, and the key, I think, concern they had was that they considered that the LVIA that had been submitted by the applicant underplayed some of the effects on the AONB. However, when it came to the point of the planning officer writing his committee report, he went into quite some detail on the AONB unit's objections. There were 30 bullet points dedicated to their comments in his report, but nonetheless, having considered them, he went on to recommend approval of the application, and indeed the planning committee adopted that recommendation, and ultimately planning permission was granted, and that led the Swire to challenge by judicial review that grant of planning permission, and she did so on a number of grounds. But for me, the most interesting one, I think, is ground one, and that was really considering the relationship between a negative screening opinion at the beginning of the process and Regulation 3 of the 2017 regulations, which effectively prohibits the grant of planning permission for EIA development unless and until an EIA has been carried out and has been made available to the decision maker. And what Mr. Justice Ouseley, it wasn't Mrs. Justice Lang in this case, she had a break, Mr. Justice Ouseley this time, what he said was that the duty, the Regulation 3 duty bites, in his word, at the point of grant of planning permission. And so the fact that a negative screening opinion has been received at the outset of the process has no legal effect in itself. It simply means that at that point, the planning authority were of the view that it was not EIA development. But if by the time you come to grant planning permission, the view has changed, circumstances have changed, and the view is that it is EIA development, then as unhappy potentially as any applicant that's got to that point would be to hear the news, you would need to stop, and you would need to undertake EIA and make sure that was before planning committee, before they granted their granted permission. But having done that, the judge then took what I think was quite a pragmatic approach to considering how that Regulation 3 duty should be carried out. And he gave three examples and three scenarios. The first of which is probably the least surprising, and that scenario is if you have a rational negative screening opinion, and subsequent to that screening opinion, there are changes in circumstance. If the officer considers those changed circumstances and comes to the view that those changes do not or are unlikely to have significant environmental effects, then that is enough to have met the duty imposed by Regulation 3, and you're able to proceed to grant planning permission. But what he then went to do as a result of the case, in the case the officer had not expressly considered Regulation 3 in his report. And so Mr. Justice Ouseley went on to consider the scenario where you have a negative screening opinion, you have changed circumstances, but there is no consideration given to whether those changed circumstances are likely to have those significant environmental effects. And what he said was that even in that scenario, it isn't necessarily a breach of Regulation 3 that would justify a quashing of the permission if, and it's a big if the court is satisfied that no reasonable planning officer, faced with that particular screening opinion and faced with those particular changes in circumstances, could have come to the conclusion, had they thought about Reg 3, that those changed circumstances would have been likely to give rise to significant environmental effects. So effectively, it was a get out of jail free card, I think, in that scenario. So if you haven't thought about it, you still aren't in breach of it, as long as you can show that no reasonable officer in your position would have come to the conclusion that it was EIA development.
And the third scenario, then, that's presumably less good news.
No, the third scenario was actually even better, because the third scenario, the judge said that he would have reached the same conclusion even had there not been a negative screening opinion in the first place. So if there just hadn't been a screening opinion, as long as at the point of making the decision, the court is able to be satisfied that no reasonable officer or no reasonable decision maker could have come to the conclusion that it was EIA development, then that is enough to mean that Regulation 3 is complied with, or at least it doesn't form the basis for quashing a permission.
Now, this all sounds like really good news, but presumably the advice to applicants and practitioners is err on the side of caution and provide enough environmental information, possibly in an environmental report, to avoid this ever being a debate.
I think that is absolutely right, because effectively the test that the judge is applying of no reasonable officer being able to come to the conclusion it's EIA development, that is effectively the Wednesbury unreasonable test that we're all familiar with in the planning system. And as the courts tell us time and time again, Wednesbury unreasonableness, that irrationality test, it has a very high bar. And so I don't think you can assume that it will be easy to persuade a court that no reasonable officer faced with the same facts would have inevitably come to the same conclusion. So you're absolutely right, Howard. For me, I think the takeaway is that the best practice must be for officers, for planning committees, for inspectors and Secretary of State to consider the Regulation 3 duty at the point of grant and decide whether it is EIA development, even if there was a negative screening opinion in the first place. That isn't enough to get you off the hook.
If you've written it up, you help them write the report. Is there a link other than alcohol to Abbots Kerwell Parish Council?
So no, not a link. I'm not even sure that there's an alcohol link. We'll move on from that. So Abbots Kerwell was not directly linked. It is, however, there is a theme. This is another Mrs. Justice Lang, so she's back. We'll end with Mrs. Justice Lang, but I really just wanted to flag it up very briefly. In that case, it was a challenge to a grant of planning permission by the Secretary of State, having recovered an appeal for his own determination. He had formed the view there was an EIA. The EIA didn't deal with climate change and greenhouse gas emissions. He had formed the view he didn't need that. The parish council, Abbots Kerwell, disagreed and challenged and said that there ought to have been more information on the issue of climate change and greenhouse gas. Mrs. Justice Lang said no, ultimately that is a matter of planning judgment. The Secretary of State, having not been Wednesbury unreasonable in that case, was perfectly entitled to reach a different conclusion to the parish council and upheld the decision. So I think there were some other grounds as well, but I don't think it's particularly interesting. But I think what I find interesting about it is the third case in pretty much as many months that has looked at greenhouse gas emissions and the question of how the approach to EIA should deal with those. You'll remember, Howard, you were part of the session back in January when we considered both the Heathrow Airport case in the Supreme Court, which was directly looking at carbon and climate change, and also the Finch case at the same time, which was the case looking at a proposal to drill new oil wells in Surrey. And the challenge there had been that the EIA had considered greenhouse gas emissions, but only from the development itself. And the allegation was that assessment ought to have also considered the carbon emissions that would arise from the end use of the oil that was going to be extracted. Now, in that case, the High Court said no. EIA can only and ought only to look at the greenhouse gas emissions resulting from the development. You can't start taking account of the carbon emissions that might happen when a car or an aeroplane or whatever starts burning that oil further down the line. I raised that one as well because actually the Court of Appeal has just granted permission for an appeal against that decision. So we'll monitor that and come back to it, I'm sure, in later sessions. But I think that potentially has very significant consequences for certain developments if we are obliged to expand EIA to take account of carbon emissions off-site from the end product. But I think that the key message of those last couple of cases is just we need to be very alive to this whole question of how EIA should take account of greenhouse gas emissions. It feels like what began as a trickle of cases risks ending up being a flood.
Yes, it's certainly in the infrastructure space. It's a matter of real interest to examining inspectors on DCOs. They very often want to know about the way that carbon and climate change has been considered. And in optioneering and decision making, there will be distinctions to be made between options based upon embedded carbon during manufacturing and construction of a project. The Finch case goes to the more remote end of things about whether one can predict the consequences years hence of the use of the scheme and the things that the scheme produces or promotes. So I'd say that I would predict, we'll see if it turns out, that that's simply too remote for the planning system to deal with.
I hope so, because if it's not too remote, it feels like it's almost certainly too complicated to try and speculate as to what that answer may be.
I think it's interesting, Trevor, that it's specifically the emissions point that's coming out now in the EIA cases, because for example, environmental information law, it's always been the case that there are fewer exceptions to disclosure of environmental information relating specifically to emissions. So it's interesting that that sort of mindset where emissions are actually subject to a higher degree of scrutiny is now potentially coming through into the wider environmental assessment regime.
I think that's right, and it clearly it's following from those other areas of the law. It's following from the Paris Agreement on climate change. It's pushed it onto the planning radar. I think now we've got to try and work out what to do with it, which is where the courts inevitably have a role to play. Great. Okay. Well, thank you for that. We've had quite a few questions coming in. Tobias, the first question everybody wants to know: did Mrs. Trent get her money back?
This is the weird thing. She did get her money back. However, the court didn't order the council to repay the money because that in effect the parties had agreed that if the notice was quashed, then she should get it back. The problem for Mrs. Trent is, and this is something to watch out for, because as I said earlier, the only way to challenge that type of CIL notice is through judicial review proceedings. But it's a trap for the unwary, which is when you actually start your judicial review, if you have paid the money on sufferance to avoid enforcement action, you need to make sure that in your judicial review claim, you also ask the court to, first of all, order the council to repay the money, and secondly, ask for interest. Because if you don't ask for the interest in the judicial review claim form, the court can't order it for you. So obviously, Mrs. Trent, it was only £16,000, he said, but a lot of these CIL disputes can run to hundreds of thousands, if not millions of pounds. And actually, if you have had £15 million, for example, tied up in the council's bank account, the interest on that is actually not an insignificant sum. So if you don't ask, you don't get. That's a very clear message from the judgment.
And sort of staying with the Trent case for a minute, another question we've had come through: if a liability notice is issued late, does that automatically mean then that you don't have to pay CIL at all?
Well, it's CIL, so unfortunately, it's not that simple. So it's quite interesting that if you read through the full judgment, for example, if you're an insomniac, every time Mrs. Justice Lang identified the council breaching its obligations, she was very quick to immediately then say that Mrs. Trent had not waived the breach. So it's slightly more nuanced than simply the liability notice is late, so we're home dry. But it does mean that if your liability notice has not been issued promptly, and if, for example, you're running up against the normal deadline to actually implement your planning permission lest you lose it, whilst it may still be a good idea to chase the council to get the liability notice so you can then do your bits of the paperwork, it is important to be careful that you don't inadvertently waive the breach in case you do end up in a situation where, for example, you just have to start work to avoid losing the planning permission, but you can't serve a commencement notice because the liability notice hasn't been issued. So it's something to be wary of, and probably something to get your legal team, if you're a developer, to have a look over correspondence before it goes out to make sure that you're preserving your position if you do end up having to bring some sort of legal challenge.
I suppose that the difficulty, as is always the case with the CIL regs, which as many will know, I am no fan of, largely because they don't seem to work, which explains why they have to be amended at least once every year. But I suppose one of the difficulties with it is there's no fixed timetable, is there, for serving the liability notice? It's this as soon as reasonably practicable, which immediately results in legal disputes as to whether it was reasonably practical to serve it sooner than the council did. I guess that there's no clear guidance that can be given there. It's a case-by-case scenario, isn't it?
Interestingly, the judgment does, and Mrs. Justice Lang doesn't sort of formally determine this, but there is a sort of almost a throwaway remark that this means sort of a matter of weeks or potentially months, not 2.5 years. So Mrs. Justice Lang is really quite emphatic about that. And I think part of the idea is that the council has to serve copies of this notice on various landowners and people interested in the land, such as a mortgage lender. And because anyone can make the planning application, then the council might, in some cases, need to investigate who those people are so they can serve the notices properly. But I think developers should certainly be cautious about sort of thinking, right, it's been a few months and the council hasn't said anything, so we're off scot-free. I think something else to bear in mind as well is that you can tell that the court was very sympathetic to Mrs. Trent's position, partly because she was an individual. Also, the fact that the reason for the development scheme was that Mrs. Trent's mother was quite seriously ill and needed personal attention. And also, I think you can tell from sort of the tone of the judgment that the court was not impressed that after an inspector had told the council they were on a hiding to nothing, they still tried again. So I think there are some general principles that you can take out of the judgment, but as I said, just be cautious before thinking that it's going to be some sort of absolute blanket principle that you would necessarily be able to rely on.
Thank you, Tobias. We've had a question through on EIA, so I think it's possibly a question for any of us that would like to take it, but I'll have a go at doing it first. A question is whether there are any proposals to reform the EIA regime in the planning bill. So, well, of course, we haven't seen the bill yet, but I believe, yes, looking at what the government has said, they are looking to, in their words, simplify the process, but without reducing the protections that are offered. They sort of seem at pains to say that they're not looking to weaken the process, which of course would potentially put them in breach of the trade and cooperation agreement that was signed at the back end of last year with the European Union, because one of the requirements of that was to maintain the same levels of environmental protection. But there would appear to be proposals to simplify the process, which perhaps means making it a little bit less legalistic and a little bit in the lines that we've been discussing today, really taking perhaps a more pragmatic approach to some of these things. But the devil will, as ever, be in the detail, and potentially in the European Union's reaction to any detail as well. So we'll wait and see. I'm not sure if anyone else on the panel has seen anything more on that.
I would just add that whilst you might want shorter regs or theoretically a more straightforward procedure, the environment continues itself to be complex. The availability of information for decision makers is critical because of all of the laws about material considerations and important and relevant considerations in the infrastructure planning regime. There will not just be EIA, but also its twins, HRA, SEA and Water Framework Directive assessment, all of which will continue to apply. And it's very difficult to see how the government can tinker with some of them in order to make things more straightforward. I remember going to see Philip Hammond while he was Chief Secretary of the Treasury, Shadow Chief Secretary, before the 2010 election, and discussing with him what could speed up the planning system. And I said, well, the big time-consuming element is EIA and considering its impacts upon procedures. And he said, well, we'll just change the law. Now, that was back in the 2000s. It's now 2021. And just as there are constantly announced biggest ever reforms of the planning system, there have been plenty of goes at reforming EIA, and as yet, none of them have achieved its objectives. I think the interesting question will be how this will interact with the Judicial Review Bill, because that will be about the standards of decision making for public authorities, how they're held to account, and that then will impact on what's taken into account environmentally.
Good stuff. I think we've probably got time to squeeze in one more question. We've had one through on the Swire case that I talked about, asking about the particular decision that that Ashford Council had taken, and how the planning officer had managed to overcome that Wednesbury level of test to persuade Mr. Justice Ouseley not to quash the permission. And I think the answer to that is that in that case, the challenge that had been brought by Ms. Swire was very much about the AONB and the impacts on the AONB, and whether they had been properly considered in environmental impact terms. And so whilst the judge found that the planning officer had not considered Reg 3 and had not gone back to think about whether the changes, particularly the AONB unit's comments, were such as to mean that EIA might be needed despite the negative screening opinion. What he had done is consider MPPF 172, which is the test for development in the AONB, and particularly the judge focused on footnote 55 to that paragraph, and part of what that requires is to decide whether it is major development in the AONB. And in doing that, one of the things that the planning officer has to consider because of the footnote is whether there are likely to be significant adverse impacts on the purposes of the AONB designation. And the planning officer had considered that, and had concluded that there were no such significant adverse impacts, and therefore concluded that there was not a conflict with paragraph 172 of the framework. And so what Mr. Justice Ouseley said is, well, look, he's thought about the AONB, he's come to the conclusion there are no significant adverse impacts on the AONB. Therefore, if any reasonable planning officer faced with that series of conclusions would inevitably have to conclude that there was not likely to be a significant environmental effect on the AONB. And therefore, in that case, that high bar was surmounted, and so the decision was upheld. So that was the get out of jail free for the planning officer at Ashford and the planning committee that relied on his report. And that takes us very nicely to 9:30. So we will end there. Thank you to Tobias and Howard for joining me this morning. Thank you to all of you for being in the audience. And as I say, the link will be posted to the website. So if you did enjoy it that much, you can watch it again. Or if you think colleagues would be interested, then of course, please, we'd be delighted if you drew it to their attention so that they could watch as well. Otherwise, we will be back for the next edition of Outline in June, and look forward to speaking to you all then. Bye-bye.
Bye.